Hi, today we're going to talk about the 5 best negotiating tips in a family law case. I'm Tom Marks with the Marks Law Firm in Orlando, Florida, and welcome to the Healthy Family Law Attorney. Okay, so tip number 1, start with superior information. You want to know your case inside and out. You want to know what are all the assets, what are all the debts, what are the income levels of the parties, what are the issues regarding the minor children. Essentially, you really have to know your case. That's number 1. Number 2, you need to know what your client wants to achieve in the case. What is the result? And you also want to know what does the other side want to achieve in the case. So superior knowledge is number 1. And in line with that superior knowledge about what your own client wants, I like to take my client aside and say, okay, what is your line in the sand? What is the furthest back you're going to be willing to settle this case for, whether it's monetary, whether it's kids issues, whatever. I also let my client know, okay, what is in bounds and what is out of bounds? In bounds is something that's a reasonable settlement, something that the court might do, or that is reasonable under the circumstances of my client's case. Out of bounds is like, no, that's to the right of right field or to the left of left field. That's something I wouldn't consider or I would advise against because it's not within the realm of what a court would do or what's reasonable in the case. Finally, I might give my client a best case scenario or worst case scenario so that when I'm going into that negotiation, I know exactly what my client wants to achieve. And my goal is to get them something that is in bounds, hopefully more than a bunt or a single, but a double, a triple, or maybe even a home run. So we're on the same page and I have that superior knowledge. Number 2, let the other side speak first. Okay, I read a really good book called The Power of Pause. And it's so important under the power of pause to be willing to let there be silence. Most people just really can't stand to let a room be silent and they want to fill that void with some words. And oftentimes you can get a better settlement offer if you're willing to just sit back and let the other side make an offer. So a good example of this is there's a famous story of Thomas Edison who invented the ticker tape, and Western Union wanted to buy it. So they said, make us an offer and we'll see if we can buy it. And Thomas Edison said, give me a couple days, let me think about it. Went home, asked his wife. She said, you should ask for $20,000, which was a huge sum of money back in that day. And so when he went back to Western Union, he walked in, they started the negotiation, but instead of making the offer, Thomas Edison sat there and was just quiet. And the Western Union official, not able to withstand the power of pause or the silence there, said, well, we'll give you $100,000. So by being silent, being willing to pause, Thomas Edison got 5 times what he would have got if he had made the first offer. There's also the concept of seek first to understand and then to be understood. That's Covey's 4th law in his book, 7 Habits of Highly Effective People. Highly recommend that book. It's a tough book to get through, 340 pages or something, but well worth it. So let the other side speak first. Number 3, be willing to say no. Oftentimes, like, in a sales situation, the salesman might say, well, this offer's only good today, or for a one-time only offer. And you get that often in family law cases, whether it's a mediation, whether it's a 4-way settlement conference, or whatever the negotiation is. It's okay to say no. I always tell my clients, you're going to feel a lot of pressure toward the end of the mediation. Things are going to feel like they're going slowly at the beginning and it'll start picking up speed. And then you get toward the end and say the mediator's been lined up for 3 hours and you've got 10 or 15 minutes left or 5 minutes left. And the mediator says, well, I'm going to have to go. And the other side says, okay, we'll do this offer and it's good for 5 minutes. Well, don't feel pressured. I don't want my client to make a rash decision and then the next day be a Monday morning quarterback and go, why'd you let me do that? How did I do that? So it's better to say no. Oftentimes, you'll get a better offer if you do that and let the other side kind of come after you for that, right? Come approach you and seek you out and try to get you to accept their offer or a better offer. All right, number 4. Okay, seek win-win. This is kind of a Covey concept too, in my mind, but it's a life principle. If you're only thinking about what's good for you, why is the other side going to consider giving you that? They're always in their mind thinking, what's in it for me? So when you're analyzing a case, you want to think in terms of what does the other side want? It's kind of hearkening back to that first principle about having superior knowledge, really thinking about what does the other side want out of the case. Cases are so much more psychological in family law. It's not just what the law says or what the facts say, but it's kind of an emotional attachment people have or a psychological attachment. So like for instance, in a case I was trying to settle at mediation, I learned that the husband really wanted the big screen TV. I think the Super Bowl was coming up. He wanted to have that big screen TV so he could have his friends over, have a party, whatever. And my client really wanted that nice violin painting on the wall. Now, the violin painting was worth a lot more than the big screen TV monetarily. And that's probably why my client wanted it, or the aesthetics of it. But the other side wanted that big screen TV for that emotional attachment or psychological or whatever. And so we traded. He got the big screen TV, my client got the violin painting. So seek win-win. What does the other side want? Really get down to analyzing that. It's a very strategic game when you're talking about negotiation. Finally, number 5, aim high, okay? So yes, negotiation is oftentimes horse trading. And if you start way over here, they start way over there, and you kind of work your way back to the middle. But it's not always that way. There's something called an extreme anchor. And so, example, I had a case, husband owned a business. We knew how much income it produced per year. And he thought it wasn't worth much and wasn't really valuing it. And I just did a mental exercise in front of him and his attorney and my client. And I said, well, okay, it throws off $500,000 a year in income. The rule of thumb on a business valuation, although I'm not a business valuation expert, and I said that, is that it's 3 to 5 times earnings is the value. So 3 to 5 times that is 1.5 to 2.5 million. Well, he was out valuing it at like 100,000 in his mind. So that was now an extreme anchor, as much as $2.5 million. So when we arrived at a number closer or slightly less than $1 million, he was happy with it, even though it was maybe almost 10 times what he thought it was way less than that extreme anchor. So that's like aim high is good. Kids do this a lot, right? They ask for the moon and the stars, and they often get something that's really a lot more than perhaps they should have, but they asked for so much. They're also good at not accepting no. They continually come back more and more. I don't know if that's a great example, but I like the example of this extreme anchor. I like really aiming high. But see, if you know what your line in the sand is, you're aiming high, so you know your line in the sand is way back here. But you also know what a single, a double, triple, and a home run is. So you're also already very aware of where you want to end up and what's in bounds and what's out of bounds. I think that if you really keep open-minded, you're very strategic. I think I've said in prior videos that I played competitive chess as when I was younger, and it's helped me to really think strategically and to think several moves ahead during a negotiation. It also helps if your attorney is good with math and can be running numbers in their head, so things in the negotiation move more quickly and more fluidly, and you're not like having to come back with a calculator and do numbers and mark it all out. Your attorney should know from the equitable distribution worksheet what all the assets and debts are, and if you move things around, how that works, and being willing to be very flexible and to achieve your client's goals, but also seek to help the other side if possible. So the 5 are, just to recap: start with superior information, let the other side speak first, be willing to say no, seek win-win, and aim high. Okay, I hope this has been helpful. My purpose is because I believe your family matters. I want to provide hope and help to your family to successfully navigate the family law process in a healthy way. Okay, please hit that bell icon and never miss a future video. Hit that subscribe button and like this. Leave me a comment. I love to receive the questions and comments from the viewers so I can put together videos in the future that answer questions that you really want to hear answers to. All right, hope that helps. Have a great day. See you next time.